Good morning, everyone. Welcome to everyone here in Carson City and those in Las Vegas and anyone watching online, either through Nellis or through our YouTube legislative channel. And with that, Committee Secretary, will you please take the roll?
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola,
Present.
Moore,
Here.
Nadeem, Ornlicker,
Here.
Roth,
Here.
Urick, Chair Miller.
Here. And please mark the missing members present when they arrive. With that, just a few housekeeping issues for today. Just a reminder that we do have 3 bills today. I will be taking them out of order. I will begin with Senate Bill 241, and then Senate Bill 46, and then Senate Bill 157. This morning will be pretty disruptive because we need to recess at 9:25. So we will recess at 9:25 and then come back about 15, 20 minutes later and then continue with wherever we are. That being said, just a reminder, please make sure that you turn off all of your bells and whistles on all your devices. We will have public comment at the end of today's meeting. We ask that presenters keep their presentations to 15 minutes and that anyone testifying on a bill or making public comment today keep their comments to 2 minutes. Again, anyone speaking will need to make sure that they state their first and last name and an organization if you're affiliated with one, and also spell your name so that we have it correct for the record. And with that, I will, let me just one more thing, give you the meeting ID for later. The phone number is 888-475-4499, and the meeting ID is 856-747-11723 for today. And with that, I will go ahead and open the hearing for Senate Bill 241. And Senator, I'll give you a moment to get settled. And do you have I see, is that your co-presenter approaching in Las Vegas? And whenever you're ready,
Thank you. Good
Please
morning,
proceed.
Chair Miller, members of the Assembly Judiciary Committee. For the record, my name is James Orenshaw. I represent State Senate District 21 down in Southern Nevada. Very honored to appear before your committee. Had the pleasure of getting to serve on this committee and know all the great work that this committee does and the great legislation that's come out. Thank you for hearing Senate Bill 241. Down in Las Vegas, co-presenting with me is my colleague, Jennifer Frazier. She is team chief of the Juvenile Division of the Clark County Public Defender's Office. And I'd have to say she's one of the most experienced attorneys in defense of juveniles in delinquency courts in the state. She has taken cases up to the Nevada Supreme Court and won landmark decisions that I think have really helped children and helped our community. Senate Bill 241 was requested by the Joint Interim Standing Committee on the Judiciary based on recommendations presented to the committee at a hearing held on April 26, 2024 by the Juvenile Division of the Clark County Public Defender's Office. Based on those recommendations, at its final meeting held on August 30th, 2024, the Interim Judiciary Committee voted unanimously to forward this bill to the 2025 legislature. Senate Bill 241 makes a few changes to the statutes regarding juvenile probation. Specifically, it does 3 things. It removes a provision allowing the stacking of probation sentences. It allows the revocation of probation if all the requirements ordered by the court have been completed by the youth except for paying off that restitution, but does not remove the requirement to pay off the restitution. It mirrors certain probation statutes to parole statutes for youth parole to ensure a juvenile is afforded due process before the child might be placed in a detention facility. Looking at the bill, the deleted language in Section 1 limits juvenile probation to 18 months and limits extensions of the probation period to a total of 36 months. According to testimony provided during the interim, it was the intent of the stakeholders supporting Senate Bill 415 from the 2023 session to prohibit courts from stacking 18-month upon 18-month sentences if the child was adjudicated of more than one delinquent act at the time of disposition by the juvenile court. This change aligns with the current disposition model in juvenile court, where there is no concurrent or consecutive time sentencing. Therefore, removing this language will clarify the law and allow the court to place a child on probation for up to 18 months or an extended period of probation totaling 36 months, regardless of how many delinquent acts the child has been adjudicated in front of the juvenile court. Section 8 of Section 1 subsection 8 authorizes the juvenile court to terminate the period of probation of a child who has failed to make full restitution but has otherwise fulfilled the conditions of his or her probation. This revision does not vacate or waive the restitution order. Instead, the youth would no longer be under probation supervision because of the inability to pay. However, the person is still subject to a civil judgment when they turn 18 years of age if there is a remaining restitution balance owed to the victim. Testimony provided during the interim indicated this revision will lower caseloads in the juvenile justice system, enabling them to more adequately manage the youth who need supervision in the community. Subsection 10 of Section 1 requires the juvenile court to hold a hearing before suspending, modifying, or revoking the probation of a child who violates the condition of his or her probation. Section 2 ensures a juvenile is offered the same rights under probation as is available in a youth parole proceeding. Currently, the youth parole statutes have specific due process provisions related to allegations of violating the terms of youth parole, whereas the juvenile probation statutes are silent. If you look at Section 2, you will see that it establishes a procedure to be used by the juvenile court when there's an allegation that a child has violated the terms of his or her juvenile probation, which is similar to the procedure already in law for allegations that the child has violated the terms of youth parole. Essentially, Section 2 requires the juvenile court to hold a hearing before ordering a child who's alleged to have violated the conditions of his or her juvenile probation to be placed in a facility for the detention of children or the county jail if the child's over 18, thereby ensuring due process rights for that youth. This concludes my overview of the bill. With your permission, Chair Miller, if I could turn it over to Ms. Fraser down in Las Vegas, then I'm happy to try to answer any questions.
Thank you, Chair Miller and members of the Assembly Judiciary. My name is Jennifer Fraser, Deputy Public Defender of the Juvenile Division. Just want to echo Senator Orenshaw explained the bill and the sections quite well. Just want to emphasize that it's our goal to always try to get consistency between the statutes, so all of the kids in juvenile court are treated similarly, so that would be the reason for wanting the codification of the procedures for the violations in Section 2 for parole to have probation mirror that, and that it's incredibly important for our kids to be able to terminate successfully from probation when they have done so well, completed all of their orders, but might not come from family of means and have the ability to pay off restitution and in the 6 months or 9 months that is originally ordered. I'm happy to remain and answer any questions that any members may have. Thank you.
Thank you so much. I will give the members a moment to request any questions. I do not see any questions right now, so at this point, I'll go ahead and open it up for. Do you have a question? Okay, actually, we do have one question, sorry. Assembly Member Urick.
Thank you, Chair. I don't know how you saw that. I sent it to Commerce and Labor on accident. Sorry about that.
They told me, no.
Yeah, I guess so. They're quick here. Thank you very much for the presentation. I was just curious about the last example was given by Ms. Fraser about the restitution and the payments, and some, use might not come from a family where they have the ability to pay that back in time. So I think I understand what's going on. When courts are ordering the payment of restitution, do they take into consideration at the early stages when they're giving that order, an individual's or the family's, the child's ability to pay that restitution, and do they set up payments and things in terms that they think they can, and then they just don't, or is it just kind of automatically set, and if they can't do it, then we end up facing this situation? I hope that is a clear question.
Thank you very much. Through you, Chair Miller.
Please go direct.
Thank you, thank you, Assemblymember Urick. Just an anecdotal, as a deputy public defender in juvenile court, with a lot of the children I've represented children who have completed all the juvenile court's orders, finished the community service, finished the classes that were ordered. They've stayed out of trouble. They tested clean on the random urine tests when the judge ordered random UAs, but they still have that balance hanging out there of trying to get that restitution paid off. And I think that if Senate Bill 241 passes, that it will give an achievable goal to kids, and if I can get all my orders done, stay out of trouble, in 6 months, I'll be off probation. Yes, the debt is still owed, the order for restitution. If there was damage to a car, if there was damage to property, if there were medical bills, that still stays, and that is submitted by the victim as to what the cost is for trying to make them whole. But the court won't lose jurisdiction on that, and eventually it can be converted to a civil judgment after the child turns 18, usually as they approach their 21st birthday. But I think we'll have kids be more successful when they've been adjudicated a delinquent child on a delinquent act and they've been ordered to be on juvenile probation. I think that having that achievable goal will have kids, be more successful versus thinking, I'm going to be on probation till I can get this, $2,000 paid off to get the car fixed. And with your permission, Miller, there might be something I missed. Could I ask Ms. Frazier to jump into?
Yes, please.
Thank you. Jennifer Fraser for the record. And just wanted to add that the court does have those conversations with the children and their families, as well as probation officers, to talk to them about what kind of extra money they have that they can contribute to the restitution. Sometimes it's as little as $20 a month. Sometimes it's more when we have larger, like Senator Orangeville referenced, there might be $2,000 balances, so that's a significant amount. But for sure, the court, as well as probation, is having conversations with the kids and their parents or guardian about what they can pay.
Thank you. Our next question is from Assemblymember Roth.
Thank you, Chair, and thank you, Senator, so much for the presentation and this really thoughtful piece of legislation. That question just sparked a question for me. And so as far as the jurisdiction on this civil matter for restitution, how long does the juvenile court maintain that jurisdiction? And do you anticipate that the public defenders will remain on as representation through the civil matter, or has there been thought about that?
Thank you very much, Assemblymember Roth. James Orangeville, Senate District 21. Under the Nevada Revised Statutes, the juvenile court can maintain jurisdiction until their 21st birthday. If there is a civil confession of judgment, I believe that whoever was the attorney of record, whether it's a court-appointed attorney, public defender, conflict attorney, or a private attorney, I believe would still stay as that attorney if there's an order for civil confession of judgment. And if there's anything I'm incorrect on, may I, with your permission, Chair, ask Ms. Frazier to jump in.
Thank you, Jennifer Fraser, for the record. Yes, I agree. Our representation is tied to the case or the petition number, not the probation status. So if our clients are terminated from probation and for whatever reason it needs to return on calendar, or if there's issues regarding the restitution or a future civil confession of judgment, our office or whoever's appointed would still be the attorney of record.
Okay, thank you for that. With that, not seeing any additional questions, I will go ahead and open it up for testimony. Beginning hearing One camera went out. Okay. Beginning here in Carson City, anyone that would like to testify in support of SB 241, please approach.
Thank you, Chair and committee members. My name is Nick Sheepek, N-I-C-K-S-H-E-P-A-C-K. I am the Nevada State Director of the Fines and Fees Justice Center here in support of this important legislation. We work with families who face fines, fees, and restitution. Fines and Fees Justice Center's position is that restitution should be prioritized and should be the thing that we ensure is paid. However, the reality is many of the families of juveniles do not have the money to pay off the restitution by the time they should be expiring from juvenile probation. This bill would allow for that restitution to continue to be collected and those juveniles to achieve all other set goals, get off probation and get on with their lives. We think it is a very smart way to handle this issue, and for those reasons we support. Thank you.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELA-KNOTT. By allowing earlier termination and concurrent service of time, this bill recognizes that young people have the capacity for growth and change. Shorter, more focused probation terms reduce the emotional strain, stigma, and anxiety juveniles face under prolonged supervision. allowing them to prioritize education, employment, mental health, and their family connections. These are all critical components for a successful integration. This bill not only is better for the youth, but it's actually better for Nevada as a whole, as shortened probation frees up valuable public resources, allowing courts and probation departments to concentrate efforts where they are most needed. Early reintegration paired with sustained support also reduces the risk of recidivism by minimizing opportunities for further justice system involvement and disruption of young persons' progress. SB 241 strikes the right balance between holding juveniles accountable and giving them a real opportunity to rebuild their lives. Ultimately, this strengthens our communities and improves public safety. Thank you.
Thank you. Is there anyone else here in Carson City wishing to testify? I will go down to Las Vegas, please.
Good morning, Chair Miller and members of the Assembly Judiciary. This is Bridget Duffy, Assistant District Attorney in Clark County, Nevada for the Juvenile Division. It's BRIGID, PUFFY, here in support of SB 241. Last session, stakeholders worked very hard on the term limits for juveniles with the probation term limits, and during the interim committee meetings, we were in support of the concept of some what we believe may have been oversight, kind of potential for possible negative interpretation of our statute. And so during this session, I appreciate the work of Senator Orenshaw and my colleague at the Juvenile PD's office here in Clark County to bring us to a point where we got to support very on, even before the first hearing in the Senate. So thank you all, and I do support SB 241.
Thank you so much. Is there anyone else there in Las Vegas that would like to testify? Not seeing any. Broadcasting, will you open the lines for support testimony?
If you would like to testify in support of Senate Bill 241, please press star 9 now to take your place in the queue.
Good morning, Chair Miller and members of the Assembly Judiciary Committee. My name is Carissa Pierce, Carissa Pearce, and I represent the Children's Advocacy Alliance as our Government Affairs Manager. CAA is an independent voice for Nevada's children with a mission to ensure that every child in Nevada thrives, and we are in strong support of AB 241 as a thoughtful bill for youth in the juvenile justice system. I will ditto the additional comments made in support of this bill, and thank you for your commitment to Nevada's children and families.
Thank you. Next caller.
Chair, the public line is open and working. There are no other callers to testify in support at this time.
Thank you. Then I will open it up for opposition testimony here in Carson City. Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone. Broadcasting, will you open the line?
Chair, the public line is open and working. There are no other callers to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony. Not seeing anyone here in Carson City. Is there anyone in Las Vegas? Not seeing anyone. Broadcasting, will you open the lines, please?
Chair, the public line is open and working. There are no callers to testify in neutral at this time.
Thank you so much. Then I will welcome the presenters back up for any final remarks.
Chair Miller, members of the Assembly Judiciary Committee, James Orenshaw, Senate 21. Again, I'd love to take credit for this bill, but the idea came out of Chair Miller's Interim Committee on Judiciary, and appreciate the hard work of the Interim Committee. I think this bill will help children be more successful when they've been adjudicated delinquent and are on juvenile probation. I think it protects the victim by ensuring that the juvenile court still maintains jurisdiction over restitution, and I appreciate the committee hearing the bill. Hope the committee might consider moving forward with it. Thank you.
Thank you so much. Any final remarks in Las Vegas?
Thank you, Jennifer Fraser, for the record. I just want to thank Chair Miller and the committee for taking the time to address these important juvenile justice issues. Thank you.
Thank you so much. So I will go ahead and close the hearing on Senate Bill 241. Okay, so that means because we do have floor today and time is of the essence, I'm going to go ahead and open up the hearing. We have about 5 minutes. So whatever we can accomplish in 5 minutes, we'll recess and come back. So let's go ahead and start with Senate Bill 46.
Good morning, Chair Miller, Vice Chair Marzola, members of the committee. Appreciate your time today and understand that it's very valuable this morning. For the record, I'm Kirk Hendrick, Chairman of the Nevada Game and Control Board. Joining me today at the table is Sebastian Ross, who is the board's Senior Policy Counsel. Also in Las Vegas, we have chiefs of the Game and Control Board divisions, and here in the audience is member Chandini Sendal of the Game and Control Board.
And could you spell your names for the record, please?
Sorry. Kirk Hendrick, Kirkhendrick, and Sebastian Ross is Sebastianross. As you may recall, when we were before this committee on AB 58, we mentioned that the intention was for the board to have grouped together all technology matters into one bill, that was Assembly Bill 58, and all non-technology related matters into a separate bill, which is Senate Bill 46. That's what you have before you this morning. Today we'll be focusing on those that, as I mentioned, are non-technology related. SB 46 seeks to make minor changes to Chapter 463 of the Nevada Revised Statutes in order to streamline and clarify processes essential for the continued success of Nevada's gaming industry. With the Chair's permission, Mr. Ross and I will address the 12 sections from the previous first print of SB 46 by topic area. The first topic is in Section 1. These amendments clarify how previously granted commission approvals and board registrations can be voluntarily surrendered to the board. The intent of Section 1 is to expressly codify the longstanding practice of the Game and Control Board and the Commission to maintain the ability to pursue disciplinary action and tax collection even if a person, as defined by NRS, wants to surrender a gaming license or if a person leaves their position with a gaming company. Specifically, Section 1 clarifies that persons who've received commission approvals or registrations from the board for a gaming license, a finding of suitability, a preliminary finding of suitability, or a non-gaming employee board registration are still within the board and commission jurisdiction if there's an attempted unilateral surrender of a prior approval. Section 1 also clarifies that the Nevada Gaming Commission regulations must establish a manner by which the industry will know how to surrender an approval or registration. Additionally, Section 1 provides that the Commission will need to pass regulations defining a reasonable time period before the board divests jurisdiction following an attempted voluntary surrender of an approval or registration. For the registration, I want to make it clear for the record that gaming employees, as defined in 463.0157, are not impacted by this proposal. Also, a conforming reference is made in Section 5 regarding the voluntary surrender of a license by a licensee. Turning to Section 3 of SB 46, the proposal clarifies that investigative hearings may be conducted by one board member or by a hearing examiner authorized by the board chair. This would bring the technology and terminology in line with the definition of hearing examiner, which uses the term authorize as opposed to appoint. The proposal also allows for one or more board members to conduct an investigative hearing without a concurrence of the majority of the board. The intent is to streamline the administrative function by authorizing a hearing examiner from the board chair, who is the executive director of the agency. Section 2 of SB 46 would conform the definition of hearing examiner to clarify that an authorization would come from the chair of the board or the commission, and another conforming reference is made in Section 8. Moving to Sections 4 and 9 of SB 46, the board is proposing, through Appeal NRS 463.169, regarding registration or licensing of a person conducting tournaments or contests in association with a gaming licensee. The board's proposal recognizes that gaming licensees are responsible for their tournaments. Accordingly, it is not necessary to register a person who conducts a tournament on behalf of or in conjunction with a licensee. However, the board has no intention to completely relinquish jurisdiction over persons conducting tournaments. Specifically, Section 4 of SB 46 would ensure that a person conducting a tournament may be called forward by the board or the commission for a finding of suitability or licensing. But ultimately, it is the licensee that is responsible for all of its own tournaments. To be clear, the proposal does not impact a licensee's own gaming employees conducting tournaments. Turning to Section 6 of SB 46.
Okay, this is where I'm going to stop you, so we have a clean break, and we can go ahead and pick back up at Section 6. So we are going to recess right now, and I do want to give you all an opportunity to leave the room if necessary. Best case scenario, we'd be starting at 9:40 again, resuming at 9:40. But so let's shoot for 9:40 right now, okay? So that gives you about 15 minutes to do whatever you need to do, and hopefully we are back quickly. So we're going to go into recess right now. All right, welcome back, everyone. We will go ahead and resume. Excuse me. I believe we are on section 6.
Thank you, Chair Miller. For the record, Kirk Hendrick, Hendrick, Chair of the Nevada Game and Control Board. And yes, we stopped at Section 6. Section 6 of SB 46. In this section, the board proposes to raise the monetary fine threshold to an amount not to exceed $500,000 for violations which are subject of an initial complaint under NRS 368A, 463, 464, 465, and Commission regulations, and an amount not to exceed $1 million for each violation in a subsequent complaint. The current limits were codified in 1977 and have not been increased since that time almost 50 years ago. However, to be clear for the record, the threshold proposals in Section 6 are not required fine amounts. The Nevada Gaming Commission currently has and will continue to have the entire range starting at no fine up to the maximum amount for each violation. And of course, the board, in its prosecutorial role, can always negotiate with licensees for a higher or lower amount with commission acceptance, regardless of the proposed increase. Additionally, Section 6 removes specified fine amounts for violating regulations adopted pursuant to NRS 463.125. Although the proposed amendment deletes fines associated with violating NRS 463.125, a licensee is still subject to the fine amounts in 463.310. The revision in Section 6 is necessary because the amount references a fine that was previously imposed for violations of a repealed Nevada Gaming Commission Regulation 6A. Former Regulation 6A was an exemption from the U.S. Secretary of the Treasury based on Regulation 6A being similar to federal anti-money laundering requirements. The federal government now solely investigates and enforces Federal Bank Secrecy Act violations, therefore maintaining a specific fine that relates to that particular prior violation is no longer necessary. And now, if the chair's approval, I would like to turn the presentation over to Mr. Ross for the remaining sections.
Thank you, Chairman Hendrick. Good morning, members of the committee. For the record, my name is Sebastian Ross, Senior Policy Counsel with the Nevada Gaming Control Board. Turning your attention to Section 7, the board proposes administrative cleanup regarding records for judicial review. The amendments provide a feasible timeframe for the Commission to transmit records to the District Court. Currently, subsection 1 of NRS 463-316 states that the Commission must prepare a record on review upon written request and upon payment of reasonable costs and fees. Subsection 3 of the statute, however, says the Commission must file the record within 30 days. Consequently, there's an ambiguity regarding what happens if the petitioner does not pay within 30 days. The proposal in Section 7 and 8.7 of SB 46 clarifies the Commission's obligations regarding transmitting the record on review to the District Court in a number of circumstances, including a petition for judicial review of a Commission disciplinary decision, a gaming employee registration appeal, and appeals for labor organization personnel disqualification. Additionally, the amendment addresses that the petitioner's failure to pay the reasonable costs and fees associated with the preparation of the record on review by the deadline is grounds for dismissal. In relation to Section 7 and 8.7, Section 8.3 proposes to amend NRS 463-3664, which would clarify the board's obligations regarding transmitting the record on review to the District Court. In this context, it would pertain to a patron's dispute. And we believe that these changes will serve as proponents for judicial efficiency. The last topic in SB 46 is Section 8, where the board proposes to raise the monetary threshold for patron dispute claims that are resolved by one of the board's hearing examiners. Raising the threshold in Section 8 would streamline the process for disputes involving less than $1,000, and this is up from the $500 that was last set in 1991. And to be clear for the record, all decisions by hearing examiners would come only after a patron has an opportunity to exercise their procedural due process rights by presenting their case at an administrative hearing. A patron would have the ability to petition if they were not satisfied with the prior decision of one of the board's enforcement agents following the investigation of the patron's disputed claim. And with that, that concludes the board's presentation of Senate Bill 46. Chair Miller, I want to thank you and the members of the committee for your time this morning, and we're happy to answer any questions.
Thank you. We do have a few questions. We will begin with Assemblymember Cole.
Good morning. Thank you for the presentation. So my question is in section 3, sub 4, where we're talking about the investigative hearings may be conducted by one or more members or by a hearing examiner authorized by the chair of the board. My question is in the comma after the word members. Is it the intent that the one or more members that would be doing the investigative hearing would be authorized by the chair or just the hearing examiner?
Kirk Hendrick for the record. Thank you, Assemblymember Cole. Very good point. And the intent here was that the investigative hearing may be conducted by one or more members at their own discretion or by a hearing examiner authorized by the board. In the second point after the comma, the reason for that was so that we didn't have a question about whether or not that member, that hearing examiner had to be appointed in a public meeting. That would go against the whole intent of an investigative hearing to have somebody talk about the hearing. But that may be a point that we need to talk to LCB drafting about so that it's very clear that a member could have an investigative hearing without, again, going back to the other members and asking. Great question. Thank you.
That was actually my question as well, so I'm going to continue with that line. So it says that it can be conducted by one or more. I guess my question is, what about initiating it? So there's a difference between conducting an investigation and initiating the need for an investigation. Can you elaborate on that?
Thank you, Chair Miller. Kirk Hendrick for the record. Yes, the individual members can also initiate an investigative hearing. As the committee knows, investigative hearings are confidential by law, and so a member could decide that they want to initiate a hearing and conduct that hearing. And the question here that we were trying to address is, again, that we didn't need the other two board members to decide whether or not there can be an investigative hearing.
But would that mean that the other board members would be notified or aware of the investigation?
Thank you, Chair Miller. Kirk Hendrick for the record. The chair absolutely would. Normally, the chair appoints the hearing examiner. In that situation, the hearing examiner would be appointed by the board member, and the other two members would be notified, may not be able to or want to attend, but they would be notified, and then they would end up getting the investigative report at whatever stage it became available.
Okay, thank you so much. Our next question is from Assemblymember LaRue Hatch.
Thank you so much, Chair, and thank you for answering our questions. So I noticed in a couple sections, especially section 2 and 3, we are replacing the entire board with just the chair. And I just wondered if you could speak to why we need that change. You know, I'm very conscious that we need to streamline some processes, but also want to balance the democratic process.
Thank you, Assemblymember LaRue Hatch. Kirk Hendrick for the record. Yes, there's been a long-standing tradition at the board that these matters do not go on a public agenda because, again, they would take away the investigative nature of it. And what we were trying to do is to make it very clear that the board chair could make that determination. That's the way it's been for quite some time, but we wanted to make sure that the statute was clear. So if anybody ever addressed it, which they have not for quite some time.
Okay, I don't see any additional questions at this time, so I will go ahead and open it up for testimony. Beginning here in Carson City, anyone wishing to testify in support of Senate Bill 46?
Thank you, Chair Miller, committee members, Misty Grimmer, Grimmer, representing the Nevada Resort Association. We're very appreciative to the board and Chair Hendricks. We worked closely with them on all the details of the language of this bill. They're very collaborative, and we appreciate that relationship, and so we are in support of the bill. Thank you.
Okay, I don't see any additional questions at this time, so I will go ahead and open it up for testimony. Beginning here in Carson City, anyone wishing to testify in support of Senate Bill 46? Thank you. Is there anyone else here in Carson City? Not seeing anyone? Is there anyone there in Las Vegas that would like to testify in support of 46? Also not seeing anyone. Broadcasting, will you please open the lines?
Chair, the public line is open and working. There are no callers at this time.
Okay, then I will open it up for opposition testimony. It's beginning here in Carson City. Not seeing any. Is there anyone there in Las Vegas that would like to testify? Also not seeing anyone. Broadcasting, will you open the line?
Chair, the public line is open and working. There are no callers at this time.
Thank you. I will open it up for neutral testimony here in Carson City. Not seeing anyone. Is there anyone there in Las Vegas that would like to testify in neutral? Also not seeing anyone. Broadcasting, will you open the lines?
Chair, the public line is open and working. There are no callers at this time.
Thank you. Then I will go ahead and close testimony and welcome the bill presenters up for any final remarks.
Kirk Hendrick for the record. Thank you, Chair Miller. Thank you, committee members. On behalf of everybody at the Nevada Game Control Board, it's been an honor to present this bill to you, and we appreciate your time. Thank you.
Thank you so much. I will go ahead then and close the hearing on Senate Bill 46. We will just wait a moment. We have a senator we're waiting on, so I'm going to text him right now. So everyone can just be at ease for a few moments. Please don't leave the room. He's on his. Of course, I will give the senator an easy time because he was flexible in waiting on me yesterday to come to committee. It's just that time in session where everyone's running around and expected to be in 3 different places at once. So with that, I will go ahead and open up the hearing on Senate Bill 157, which revises provisions relating to the testing of cannabis and cannabis products. So Senator, your hearing's open. Whenever you are all settled and ready, please proceed.
Thank you, Madam Chair. I was catching my breath here as I ran up the stairs. Good morning, everyone. I am State Senator Edgar Flores, proudly representing Senate District 2, and I am here to urge you to puff pass Senate Bill 157.
Senator, will you first introduce your co-presenters and everyone spell their name?
Oh, wow.
Yeah, we go for accuracy in this house, so please.
Thank you. Well, rather than me making the mistake of misspelling anybody's last name, including Mr. Adler's, I will allow them to introduce themselves first. And Madam Chair, I will be brief in my opening remarks, and then I will allow for our experts to join the table who are best situated to answer any questions you may have.
Will Adler, representing Silver State Government Relations and GTI, Green Thumbs Industries. My name is Will, W-I-L-L, Adler, A-D-L-E-R. Thank you for having us.
My name is Glenn Miller. I'm a retired faculty member at the University of Nevada. I'm working with proponents of this bill. And my name, Glenn Miller, G-L-E-N-N, 2 N's, M-I-L-L-E-R. Thank you.
And Madam Chair, I do believe we have somebody also joining us via Zoom.
Yes, I believe that. Right now, what's happening is they had to, because of all the stuff going on in the building right now, you'll notice they just gave us the wide Zooms right now until everyone returns. So I will leave it up to you if you want to proceed, if that person's just there for questions, because we can Zoom will be back available once they return, which is any minute now, so.
Understood, and we'll do that, Madam
Okay,
Chair.
thank you.
And again, for the record, I am State Senator Edgar Flores, representing Senate District 2. So by way of background, I had an opportunity during the interim to work with Mr. Adler and identify different areas of policy that I thought were important for us to address. I myself am a small business owner and understand the complexities that we often confront as business owners with red tape. And specifically as it comes to the cannabis industry, all of you have heard how the unregulated market has made it very difficult for a lot of the folk who have invested every penny that they have into this space to really make profits and really make it work. Now, I start by making that point because in engaging in that conversation, it became abundantly clear to me that as a state, we have an obligation where we bought into this idea years back and said we're going to regulate this, we're going to create a gold standard. That part of that negotiation, part of that deal was to ensure that we were also protecting the business sector, not just the consumer. I think it was a relationship that we all kind of engaged together because we said, you're going to buy into this idea that Nevada is open for business. And at the same time, we're protecting the consumer. What are we doing to ensure that those businesses are protected through legislation? So in engaging in those conversations, one of the things that we were talking about is when we originally started having the cannabis conversation in the state of Nevada, we were all new to this conversation. There was a lot of things we didn't know. We didn't have enough data backing up a lot of the different things that we were doing, including how we were implementing some of these requirements and imposing them. Now, one of the things that we looked at was right now we're testing at a 5-pound lot size. As you know, the bill looks to change from 5 pounds to 50. Arbitrarily, really that number is how we came up with it because there was no real data or science saying that that's what the number we needed to do. We've looked at the state of Washington, who is the last state who had the 5-pound lot testing amount and changed it to 50 pounds. That's how we decided that we wanted to go and do something similar in the state of Nevada. And the reason for that is there's no need to reinvent the wheel. They went through a very lengthy regulatory process. They invested a significant amount of resources into ensuring that that made sense. So rather than trying to come up with a random number, which I believe is what we did initially when we picked the 5 pounds. We said, let's look at a state that's done it. And more importantly, that they've done it in a way that we thought was very responsible, that adheres to 2 very important things. Number 1, we do not want to lower the standard, the quality, and at the same exact time, we also want to make sure that we are not in any way putting anyone's health at risk. Now we have years in looking nationwide where, by the way, they are not testing at 5, they are testing at numbers that are significantly higher, where we've noticed that we haven't decreased, or that there's a correlation between the quality of product, or a correlation between individuals saying there is some health concerns and the fact that we changed the lot size. There is no correlation. With that, before I hand it off to our co-presenters, and who are really the experts in the room, I also wanted to make it abundantly clear, this conversation did not just start this session. It's been ongoing for years now, namely spearheaded by Mr. Adler, in trying to see if through regs we could address this issue. Unfortunately, the conversation has gone nowhere in the vetting that we would have wished, and the thorough kind of approach to that conversation that we wish would have resulted did not occur. So then we find the need to come and do it at the state level. In addition to that, I've also had an opportunity to speak with the opposition, Mr. Adler, in much greater detail. I've had the privilege of meeting with a lot of the folk that do test today, and I appreciate their passion. I appreciate the quality of work that they do. Obviously, they want to ensure that they have the best quality product out there in the state of Nevada. And so I'm very respectful and mindful of that. But in trying to find a middle ground, a negotiation number, there hasn't been one. The opposition simply wishes for the bill to not move forward, which I'm respectful of, and they will present their arguments in that respect. But we have tried, and we've asked for them to throw any number at us that they think makes sense and is backed by data, backed by research, backed by science, and there has been no number. Despite the fact that the entire country is not at 5, there is no number that was thrown at us. So respectfully, it was just difficult for us to make it work, but I am mindful that there is opposition, and I don't want to downplay them, and ultimately I will commit to what I said in the Senate, which is if there is a number that is backed by data, research, and science that makes more sense, we are open to negotiating to a different number. And with that, Madam Chair, if I may pass the presentation to Mr. Adler.
Thank you, Senator Flores. Will Adler for the record. I'm actually going to hand it over to Dr. Miller, and then I'll do some concluding comments. And it looks like Dr. David is also on the Zoom. And I'll wrap up and enter into the questions afterwards. Thank you.
Hi, my name is Glenn Miller. I was a professor, I'm a emeritus professor, University of Nevada at the Department of Natural Resources and Environmental Science. I'm a chemist, environmental chemist by training. And about 10 years ago, when the discussion on cannabis began, I became interested in that. We'd done some work. We had a hemp project at the university, and we were measuring potency issues, how much THC, how much total CBD was in various plants. So I got very familiar with the analytical aspects of measuring potency of the products. And I was also on the Independent Laboratory Advisory Committee, ILAC, which is the first committee that was trying to determine what should be measured and what were the limits of detection. I was a little frustrated with that committee because a lot of times the agency would actually pass a regulation and then say, is it okay with you guys? And more often than not, we said, no, it's not. It's there was an issues with how measurement was done. There was some number issues that came up, and all of those kind of resolved over the period of time. And after about a couple of years, I think I was no longer on the committee. But I remained interested in this issue over time because it's important. I mean, cannabis is not all good. There are some downsides to it, and it has to be respected as it is a drug. THC is a drug, and so we want to be careful about what kind of things we regulate. The point of all of this is that the lot size is a focused issue. Illegal marijuana does not get any testing really at all. We don't know how much testing, but it's probably not any. And so the risk of using cannabis products is greater for those because there is no regulation on that. And right now, the lot size is such that it puts a severe and substantial cost on developing of cannabis products. And 5 pounds, every 5 pounds, you have to spend several $100s doing the analytical work. And it simply doesn't make any sense because it makes the legal product, which is going to be much safer than the illegal product, it makes those so much more expensive. The people will say, "Oh, the hell with it, I've been smoking weed for a long time, I'm just going to continue buying it illegally and save a lot of money." And that's the crux of the issue is product safety. And how can we make the product safe, but keeping the cost down to reasonable sum so that we can regulate, protect the public, and at the same time keep the price down, as opposed to have unregulated material, untested material that you can use anything on because it's completely illegal. And that's where this lot size came in. When I was on ILAC during those first years of cannabis development as a product, it seemed at the time one of the things that's not very much marijuana to test each of those, and so it ends up being quite a bit expensive. I'm a lab guy, and I I know how much these things cost and what the necessity of having good quality labs is, and they're going to probably take a hit on this because if you reduce the size of the cannabis testing requirement from 5 to 50, 1 in 5, 1 in 50 are the test subset of 5 pounds versus there's about almost a tenfold difference in the analytical cost. And that's a large difference, and that is the kind of issue that we're looking at. In comparison with Nevada, with other states, and Washington's probably the best one. They've gone through. They have outdoor grows. They have a lot of differences, I suppose. But they made the decision that 5 pound lot was too low and it cost too much money for those users, and it encouraged them to use illegal products. And so the 50 pound is reasonable, and the way you do that is you subsample, and the same way we do with foods. Everyone, we have safe foods in this country because there's a lot of testing that goes on to make sure that the foods don't have excessive amounts of pesticides, excessive amounts of mercury, are not contaminated with molds, those sorts of things.
Can I just ask a question? We generally keep our presentations to 15 minutes.
Okay.
And you have another speaker, so I'm not sure, is he speaking or is he responding to questions?
Yeah, we'll wrap it up.
Okay, so yes, please
The bottom
wrap
line
it up.
is the risk of having a 5 pound lot is much higher than a 50 pound lot, simply because it encourages illegal use of products. Thank you.
Okay, thank you so much.
I would like Dr. David to get in his comments on Zoom, please, and then I'll, like I said, wrap it up and enter into questioning.
Okay, Doctor, we're at 15 minutes, so I'm going to ask you to be concise with your remarks.
Sounds good. Good morning. You can hear me okay?
Yes, we're all set. Yes.
Awesome. Okay. So yes, hi, I'm David Valancourt. For the record, David, D-A-V-I-D, and then Valancourt, V-A-I-L-L-E-N-C-O-U-R-T. And so I'll get started. All right. So good morning. Yeah, sorry I can't be here in person with you all. I'm the CEO and principal consultant of the GMP Collective and the vice chair of ASTM International's Committee D37 on cannabis standards. I started after grad school in analytical testing for environmental samples and foods, did that for about a decade, and then since 2017 have been supporting the cannabis industry in defining and utilizing best practices. I'm here today to explain why the Nevada 5 pound batch limit on cannabis flower, which is the strictest in the nation, is outdated, costly, and does not importantly, provide any safety benefits. I'll also briefly explain how adopting ASTM's science-based sampling standards will better protect consumers and reduce these unnecessary costs. So about ASTM International, ASTM's 125-year-old nonprofit standards development organization creates rigorous guidelines trusted and used by regulators, consumers, commercial companies worldwide. Everything from railroads to roller coasters, medical devices, bicycle helmets, and so much more. You can rest assured there's an ASTM standard ensuring their safety. If any of you has a highlighter, I know I'm not in the room, but if you have a highlighter handy or can find one after, pull it out and you'll actually see below the AP mark, it says conforms to ASTM D4236, and that's to ensure that the product is not that's certifying that the product is non-toxic and safe for use. In case any small children that have a tendency to put things in their mouth will not end up in the emergency room because of poisonous byproducts in those products. These standards generally are responsible for our everyday safety. In fact, the federal government in the United States has incorporated over 3,000 ASTM standards into federal regulations directly. And since 2017, there's more than 600 experts developing cannabis-specific standards under this committee, where I serve as the vice chairman, including many members of the Nevada Cannabis Compliance Board, Health Canada, and other public health agencies from across the country and internationally. So why do we currently have a 5-pound batch limit, which is the smallest in the nation? Some may recall that back in 2013, the first study on this topic was conducted by a policy and research firm, BOTEC Analysis for the state of Washington, which did recommend a 5-pound limit. It's worth noting what BOTEC stands for and how they got their start. BOTEC stands for literally back of the envelope calculations. And that's exactly what they were able to provide in 2013 when there was no data. Over a decade later, today, we've got nearly 40 state legal marketplaces and the entire country of Canada, as well as many nations internationally medical programs. Canada and every medical nation has no batch size limits, and they have no safety issues compared to states with batch size limits. So simply capping lot sizes at 5 pounds does not yield safer cannabis. Even the state of Washington that commissioned that report have expanded beyond the 5-pound limit without seeing any spikes in recalls or adverse events.
Okay, I'm going to ask you to wrap up your comments, please. To wrap
Okay,
up your comments.
sounds
Thank
good.
you.
Yeah. All right. Yes. So, as mentioned earlier, no other industry, whether it's food, dietary supplement, or pharmaceuticals, has regulated caps on batch sizes to ensure safety. Rather, they focus on the strong sampling methods, which are incorporated into your rules currently. So, my takeaway here is to test smarter, not harder, and eliminating the 5-pound limit in Nevada and continuing to embrace ASTM International's consensus standards will better protect public health and safety, reduce those financial burdens, and keep the state of Nevada at the forefront of safe, responsible cannabis regulations. Thank you.
Thank you so much, and you corrected yourself on the pronouncing the state, so I didn't have to. Thank you so much. It is Nevada, yes. So with that, we do have some questions. We will start with Assemblymember Cole.
Thank you for the presentation. So my question is related to where we're talking about the cannabis hemp post-harvest batches for laboratory analysis. And then you've got representative samples of a lot of cannabis flower to be, and then in D, you've got the following number of representative samples to be collected from each lot of cannabis flower. And then you go on and you talk about the 10 pounds, 20 pounds, 30 pounds. And later on, you're talking about leaves and flowers and wet flower, but those references are nowhere else, if that makes sense. So I'm wondering if in subsection D, cannabis flower is correct, or if it should just be lot of cannabis or lot of post-harvest batch, maybe. And you may have to look at it later and do sort of a deep dive on it, but I'm not sure that it's an accurate reference.
Will Adler for the record, representing GTI for the record again. Yes, so just to be more explanatory than maybe necessary, there are multiple ways you can test cannabis in the state of Nevada. You can test it in lots of condensed flower, sort of the bud or squishy, matrixy flower that you think of when you think of smoking bud, right? But there is wet leaves or sort of things that are meant to go to extract, and they are sort of identified separately as trim or wet trim or wet weight plants. So you don't actually dry it. You actually harvest the plant whole and wet, and you dry that additionally. So I think they're just trying to encompass the current testing language that we use today in the state of Nevada and sort of use that against the Washington state regulations we encompassed to make the core of SB 157. But I could get more details and get that back to you for clarification to make sure it does check the box in the right places. Generally, though, the concept is to have an increasing weight limit from, as it states in the bill, less than 10 pounds shall have 8 samples or 8 grams of flour or greater shall be sampled at minimum from each sampling, or up to 50 pounds where you shall have at least 19 samples taken from a larger sample size shall have more representative samples taken from it. But I think the same gradient would be true in these cases, but just larger trim lots today are larger, and you do take one fixed sample size for those. So I think it's kind of reflecting the higher value and need for specificity in flour testing than the other products we're talking about today.
Sorry, thank you. So I understand what you're trying to get to, but I'm just saying that your subsections 1, 2, 3, 4, 5 of that section refer only to lots of cannabis flower. And I don't think that the trim and the wet leaves and everything else are cannabis flower. So just look at it from a layman's perspective, or have your attorney look at it just to make sure it does what you want it to do. Thank you.
Carly O'Krent for the record. Assemblymember Cole, if you may have seen, but subsection 3, paragraph B defines lot to include the flower, the leaves, and other plant matter, etc.
Okay, thank you. Our next question is from Vice Chair Marzola.
Thank you, Chair, and thank you for the presentation. I was trying to write my questions down, wrapping my head around cannabis. Okay, so I have a couple questions, if that's okay, Chair. Yes. So the first one is, you guys keep using Washington as an example. Do we cultivate the same way in Nevada that Washington does?
Will Adler for the record. Generally, cannabis is grown in a similar fashion. There are several indoor cultivations in Washington state, but they do have more outdoor cultivations as they have the climate for growing cannabis outdoors, whereas Nevada does not. We have addressed this many times on the record that this is Washington state's language, and this is sort of their poundage and their sampling, parameters. And multiple times I do think there could be the argument that Nevada doesn't usually have as large a harvest of a single strain on a single harvest date as you would see in a mass outdoor grow in Washington state. You'll have a whole row be the same strain, and you actually get multiple batches out of one outdoor field. You'll end up with 250 pounds sometimes. So that's where you would see this language more applicably applied, maybe to Washington state and outdoor grows. But we wanted to keep it because their study and their value of proper sampling with larger weight sizes. We saw value in that, but it is true that this is Washington state language and applies to their specificity. But that's why we did want to have this conversation at the regulatory level, and sadly did not have that with the CCB for a couple of years. But we're open to hearing what might be appropriate for Nevada.
Thank you. Follow up. Thank you. You brought up the CCB. So have you discussed increasing the lot size with them before this?
Will Adler for the record. Yes, we actually provided a document from Silver State Government Relations sort of entailing partially the history. We actually just wanted to keep it to 2 pages of all the inquiries to the CCB, the communications to their director, the direct petitions, and inquiries for inclusion on any of the work sessions. But we were never actually included on a work session or on a public agenda, so they actually can never be discussed. And there was never any public comment from the entirety of the cannabis industry for almost 2.5 years or 3 years now. We have tried to have this conversation, have that regulatory stance, because we do feel like it would be a longer build out. But actually the last hearing was a direct petition to the board, and they stated that they didn't want to take this on because they thought the legislature was coming too soon and that regulatory changes weren't worthwhile at that time, that they thought the legislature might be the appropriate vessel. So we've done all we could, truly, at the CCB level.
Thank you for that. Last question, Chair, I promise. So I got your map. Can you tell me what the average batch size is? So you're asking to go from 5 to 50, which to me seems like a lot. But again, I'm not in this space, right? And it seems like in the map, you used green for the same green, unless I'm colorblind. from 20 to 25 and then 40 to 100. So I'm trying to figure out what is the standard or the average size.
Will Adler for the record, yes. And to clarify a little bit more, we did put some bold language above the map. But the majority of cannabis markets are of a batch size larger than 25 pounds today. And in fact, 60% of the states have a maximum batch size above 25 pounds, just as a whole. And then, in the western United States, you can kind of see that it's green on green. But I do think Washington State, we did use their language, is up to 50 pounds. Oregon's at 25 pounds. And I think California is at 50 pounds. But it is kind of all one green there.
And I did see that it's above the 25 pounds, but above could be 30, right? Doesn't necessarily mean it's 50. So that's what I was trying to figure out. Thank you, Chair.
Thank you, Vice Chair.
And Madam Chair, if I may add one quick
Yes,
comment.
please.
Senator Edgar Flores for the record. And as I alluded to it before, we are open to any number, and it's just not one number has been proposed by anybody else. But we are open to any number, working with anybody on any number that they think is reasonable.
So would you accept 6?
We are open to working with any number, not agreeing to it, Madam Chair.
Okay. Thank you, Senator. And I'm actually still stuck on the comment that they thought the legislature was coming too quickly, like every 20 months, but we'll keep continuing with questions. So our next question will be from Assemblymember Moore.
Thank you, Chair, and thank you for the presentation. I do have a question similar to what the Vice Chair was asking. This bill is based on Washington State language, and we're going for 50 pounds. And earlier it was mentioned that you all are open to working with the opposition on finding a number that's based on research and science. Now, is the 50 number also based on research and science?
Will Adler for the record, yes. We can sort of go through the whole history of Washington State, or we just sort of look at the map at large, across the country. And this is kind of the issue proposed by GTI just as a multi-state operator. They actually operate in somewhere around 20 states across the United States, and they've brought this forward to Nevada multiple times as a process issue or more of a mechanical issue where they've identified the majority of the failures they had in Nevada was actually due to human contamination and from the repackaging and touching of these products on multiple strings. Because I just wanted to point out, we did take a very long look at how to approach this issue correctly for lot sizes in Nevada. And Washington State did a very long, intensive study, and they really identified what is appropriate increases to sampling when it comes to increases to lot sizes. But we also wanted to add in the ASMR international regulations to say we should have standardized practices when it comes to the sampling of cannabis because, frankly, in the past, it's gotten a little dicey. Sometimes, you put the sugary ones on top and the highest THC colas happen to be the one that got picked by laboratories. So we did actually want to codify better practices in laboratory standards and in the sampling that could be found there because that's worked in multiple states and multiple jurisdictions. And GTI sort of identify this as Nevada is, and you can kind of see small batches, not to protect customers. It's just a general ranking. Nevada did rank 148 out of 200 when it came to cannabis testing safety standards, but states with larger batch sizes like Maryland, Pennsylvania, and Connecticut actually scored higher, whereas they have larger sample sizes. It actually goes to how you sample, what you sample for, and what you test for. But in the bill, we explicitly did not touch what you test for in the state of Nevada. We kept the exact same standards when it came to the stringency of colony-forming units. We do not touch anything when it comes to pesticides, heavy metals, or any of the dangerous contaminants that actually are on the product. We want you to have to pass the exact same test, but if a company chooses to test more product at once, that is on them, but they need to pass the exact same safety standard Nevada's already established. Thank you.
Quickly, and I just want to remind folks that we do have floor, and I believe there's a lot of people to testify, so quickly, please.
Thank you, Chair. Just something around safety. How do we know that increasing the size limit of the lot sizes will safeguard public safety and the public health?
Yes, Glenn Miller, I think it's best to look at this as the way we're testing foods. How do we know those foods, most of which, except for the organic version, most of it get an application of various agrochemicals. Some risk, some not. We tested a very small percentage of those with the expectation that the industry, the worst thing that can happen to the industry to have a whole lot discarded. And so it's a question of again, the lot size, the cost, and by the ASTM method, it does subsample things. It's probably not the amount of difference in risk is not very much for 5 to 50. But the biggest issue is it makes the big product so expensive that people will go to illegal. That is the risk that I've seen and perceived as the biggest problem. 50 pounds, subsampled as appropriate using the ASTM indication will protect the public. I mean, just like smoking cigarettes, the big issue is the smoking. If you're smoking cigarettes, it's not the nicotine that's a toxic, it's all the other stuff that happens when you burn products. So that won't change. You smoke a joint, it's going to have combustion products you're going to get into your lungs. But the difference in those regulated commodities that we look at is really not very substantial. If you lose a 50-pound lot, you lose a lot of money because the regulations say you have to throw away that 50 pounds. And that's a big risk. That's an expensive proposition. But so people are going to be reluctant to have a product tested 50 pounds that they might lose on. It's a complicated issue, but as far as the food regulation of everything, it is felt that the amount of food testing that we do is appropriate, and that's much less than what we're suggesting for cannabis species.
And Madam Chair, Senator Edgar Flores, for the record, thank you for the question. I just wanted to make it abundantly clear that we've also looked at other states that have increased their lot size testing, and there is no correlation or data to suggest that after they changed the lot size that they were testing, that somehow there was an increase in quality, a decrease in quality, or increase in health concerns. And so that's what gives us a comfort to be here today before this committee.
Thank you. Our next question is from Assembly Member LaRue Hatch.
Thank you, Chair. Thank you for being here today for our questions. So my question is specifically about the Cannabis Compliance Board, and you mentioned that you've brought this up for many years and they're refusing to talk about it. I just wondered, can you speak to the reasons that they have not wanted to address this, or what they've said for why they do not want to change these standards?
Will Adler, for the record. I can't speak to why the board or the staff of the Cannabis Compliance Board, to be more specific, had so many qualms with actually addressing the lot size as the regulatory standard it is. But from multiple petitions and multiple attempts to get it into hearings, at each step of the journey, we have seen loud opposition from the laboratory fronts in the state of Nevada, asking some of the same questions or declaring some of the same things. Around no proof around a lack of safety in, standards degrading. And the same questions have been floated back and forth of how can another state do these things where Nevada has kept it at 5 pounds? But the inverse is now true as time has gone forward. In fact, some of the last holdout states that we're pointing to, like Washington State, actually adopted a new regulation around having more streamlined flow of testing and processing of product in these businesses. They identified that as causing more slowdown and harm than good when it came to the stringency of the test. So I cannot speak to why the board didn't take it on directly, but our efforts were in true faith to just have the conversation and get to whatever the scientific means would be. But to this day, they've yet to, so we did bring forward this bill.
Thank you. Our next question is from Assembly Member Ornlicker.
Thank you, Chair, and thank you for the presentation. So I'm thinking about, you've given us comparisons with other states with regard to cannabis, and you've also said, even with this, the rules would be stricter than with food and pharmaceuticals, if I'm remembering correctly. And thinking about this before the hearing about what would be analogous, as Professor Miller, you mentioned smoking cigarettes is kind of analogous to smoking a joint. And what's the testing for tobacco? How does this compare, what you're proposing, to testing for tobacco that's going to go into cigarettes? Do you know that?
There has not been that much testing going. David Delacourt is probably more acquainted with this issue than I am, but it's the question is pesticides in tobacco is what kind of testing goes on there. There has been testing. In fact, a friend of mine at UNR in the College of Agriculture did testing of what kind of contaminants come out, and they're horrendous. Cigarette burning vegetative material like that, dried vegetative material. Looking at some of the toxins that come out, polycyclic air, all that chemistry stuff that nobody's probably terribly interested in. That same issue is probably the biggest risk of smoking a joint. You don't smoke 20 packs or 2 packs of joints a day. I don't think many people do. So it's probably not as bad as smoking cigarettes, but it's still, that is probably what I consider the biggest risk of smoking a joint, is the fact that it's similar to vegetative material smoking and all the chemistry that kind of happens with that, not the amount of pesticides, which are regulated very tightly by Nevada and most other states as they come in. So the risk of this is reduced because we do test, but the cost is going to be reduced because the amount of testing that has to be done. And that is the primary argument that I would make, is the risk is much more severe of having a big difference in cost because people are going to buy the less expensive illegal product.
I'll briefly add for the record, David Valancourt here, that in terms of tobacco testing, one of the things the tobacco industry has made clear is that it kills about 50% of its users during its lifetime. So they haven't taken a very strong stance in terms of testing approaches. They're also exclusively outdoor grows, so these are significantly large crops. There are no batch size limits for tobacco leaves as well, and their testing is significantly reduced compared to the cannabis industry for kind of all those reasons. So I always encourage folks. It's a really great question, and it comes up a lot. I encourage folks to be better than the tobacco industry. The cannabis industry does have medical benefits, and I think that's important to test more rigorously than the tobacco industry does.
Okay, thank you so much. With that, not seeing any additional questions, I will open it up for testimony and support. So those wishing to testify in support, starting here in Carson City first, on Senate Bill 157. Please fill up the chairs. Proceed.
Good morning, Chair Miller, Vice Chair Marzola, and members of the committee. My name is Drianna Dimatulak, Drianna Dimatulac. I'm with Brownstein, representing Deep Roots Harvest, in strong support of SB 157. The current processes for cannabis testing are onerous, time-consuming, and costly. As the cannabis industry has matured, it's clear that the existing requirement limiting cannabis lots to no more than 5 pounds is overly restrictive. SB 157 is a timely innovation that balances public safety concerns with industry efficiency. SB 157 proposes a sliding scale for lot testing sizes, which will modernize and streamline the cannabis testing process. This change will reduce costs across the supply chain for manufacturers, retailers, and ultimately consumers, while also upholding consumer safety standards. For these reasons, we respectfully urge you to support SB 157. Thank you.
Morning, Chair. Brett Scolari, Strategies 360, SCOLARI, here on behalf of Cura Cannabis Solutions. First, we'd really like to thank Senator Flores and all the folks that worked on this bill. We are in support, and I just wanted to add one thing without taking up too much time. Previous to Strategies, I was in-house counsel for one of the largest growers in the state, and I can tell you Every room was different in their facility. There was several strains, there was different size rooms, and those strains each produced different amounts of weight when they were harvested. So this isn't a proposition where all of a sudden everybody's going to start submitting 50-pound lot tests. I think you're going to see some flexibility and some flexibility for operators as they plant their rooms and have different strains in those rooms. Different weights are produced by those strains. So I think it's a good balancing act between the safety and the flexibility for operators. Thank you.
Thank you. Anyone else here in Carson City? Not seeing anyone, we'll go to Las Vegas for support testimony.
Good morning, Chair Miller, Vice Chair Marzola, and members of the Judiciary Committee. My name is Lake Martin, Laykemartin, and I'm the Executive Director of the Nevada Cannabis Association, which is the trade association for licensed cannabis businesses here in Nevada. We represent licensees of all sizes, from small independent cultivators to large multi-state operators. We like the sliding scale proposal of SB 157 because smaller grows can continue to do what they're doing now, which is testing small lots, and larger operators can test larger lots. And importantly, the representative sampling increases proportionately. This will streamline operations and reduce labor costs and enable us to do in Nevada what 35 of 38 states are doing already. In our view, we cannot have a successful cannabis industry if we do not update old standards when we have new and better information. As the experts noted, the standard for lot sizes was adopted 10 years ago before recreational cannabis even launched in Nevada. Now, 10 years later, we have years of data from more than 30 other states and national standards recommended by the independent testing group ASTM you heard from Vice Chair David Valancourt. We know that lot sizes can be increased above 5 pounds safely because nearly every other state has done so. And we urge this committee to support this much needed change here in Nevada. Thank you.
Thank you so much. Is there anyone else there in Las Vegas? Okay, not seeing anyone. Broadcasting, will you open the lines?
If you would like to testify in support of Senate Bill 157, please press star 9 now to take your place in the queue. Caller, you are unmuted and may begin.
Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Judiciary Committee. My name is Brandon Wigand, Brandon Wiegand. I serve as the Chief Operating Officer of Harding Dispensary and a board member of the Nevada Cannabis Association. I'm here today to express strong support for Senate Bill 157. The important legislation addresses a critical inefficiency in our current cannabis testing requirements by allowing for a more practical approach to batch testing through a sliding scale of up to 50 pounds. Nevada's current 5-pound limit is among the most restrictive in the nation. In fact, 35 out of 38 states with legal cannabis markets permit lot sizes greater than 5 pounds, with 13 states having no limits whatsoever. SB 157 incorporates the internationally recognized ASTM standard D8334 for cannabis sampling, ensuring representative samples increase with lot size, from 8 samples for lots that are 10 pounds to 19 samples for lots between 40 to 50 pounds. The practical impact of this bill would streamline operations through simplified inventory management with fewer testing lots to track, reduced administrative burden in data entry and labeling, and more efficient compliance reporting and documentation. While the Nevada Cannabis Association made numerous attempts to engage testing laboratories in collaborative discussions about this legislation, these outreach efforts were largely ignored. The standards incorporated in this bill are well established and successfully implemented in other states. I respectfully urge this committee to support SB 157 and help modernize Nevada's cannabis testing regulations based on established standards and industry best practices. Thank you for your consideration.
Thank you so much. Next caller.
Chair, there are no other callers to testify in support at this time.
Thank you. Then I will go ahead and open it up for opposition testimony here in Carson City.
Good morning, Chair Miller, Vice Chair Marzola, and distinguished members of the committee. My name is Jennifer Lanahan with Western Public Affairs. I'm here representing 374 Labs, Digipath Labs, ERP, and MA and Associates. I just want to start off by thanking the bill sponsor and the proponents for trying to engage in some negotiations, some dialogue. We have been working with them. It's just not the position right now of the labs for us to be able to negotiate against the public safety. We have significant consumer protection issues that we feel need to be addressed that haven't been thus far. I have next to me, this is Alec Garcia. He is the owner of 374 Labs. Some of you have possibly met with him before. He's really the subject matter expert and can speak to some of the questions I think that some of the committee members had. With your indulgence, Chair, I will pass it along to Alec. Thank you.
Good morning, Chair Miller, members of the committee. For the record, my name is Alec Garcia, A-L-E-C-G-A-R-C-I-A. I'm a small business owner at one of the independent testing laboratories here in Nevada, 374 Labs. I'd like to express my opposition to Senate Bill 157. 6 of the other laboratories in the state have also submitted written opposition to this bill to the sponsor. As independent laboratories, we are tasked with ensuring that products are safe and accurately labeled. Labs protect public health, build consumer trust in this developing market. This bill ultimately comes down to one thing, and that's patient and public safety. Our ability to accurately detect contaminants depends on the percentage of the product that we test, and that depends on the lot and sample size from which we collect. The lot size and sampling frequency is not a subjective science, it's simple statistics. This is backed by the BOTEC paper. I thought it was interesting, the proposed lot size in this bill directly conflicts with the ASTM protocol, which has been referenced here multiple times and was mentioned earlier by Dr. David. Section 4.2 clearly states, a harvest batch size for inflorescence shall have a maximum weight of 15 pounds. This aligns with Nevada's current lot sizes of 5 pounds for flower and 15 pounds for trim. Saying a 10-fold increase in the lot size won't harm public safety is like saying that doubling the speed down Las Vegas Boulevard to Virginia Street won't impact people. The CCB has also done their own investigation on this issue and has been cautioned from other states. They also investigated cost analysis associated with testing and came up with 8 cents a gram, less than 3% of the final retail cost. California has had multiple issues with recalls based on their larger 50-pound lot size. Bigger lot sizes mean unsafe product that will reach consumers, product recalls, and greater damage to public trust.
Your 2 minutes are up.
Sorry, I'll say all I think we need to do here is we need to protect that trust, not put it at risk, and protect the patients, consumers, and tourists that are here visiting Nevada. Thank you.
Thank you so much. Is there anyone else here in Carson City? Again, please fill up the chairs so that we can, yes. Anyone else here in Carson City that wants to testify in opposition? Okay, proceed.
Hello, thank you, Board. My name is Wyatt Beadleston, W-Y-A-T-T-B-E-A-D-L-E-S-T-O-N, representing G3 Labs LLC today. With nearly 8 years in Nevada's cannabis industry, I'm here today because Senate Bill 157 raises serious concerns. This bill proposes increasing testing lot sizes tenfold from 5 pounds to 50 pounds. This dramatic increase without a clear plan for representative samples creates a significant public health hazard. Contaminants in these batches aren't evenly distributed. Larger lot sizes means there's a greater chance for unsafe products will pass through unnoticed. This isn't just a theory. We've seen consequences in other states with similar roles. I urge you, please consider these facts. Washington State has experienced over 500 cannabis product batch recalls since 2024. California saw an 800% increase in recalls in 2024. Enforcement actions are up more than 300% this year. Colorado had up to 1,600 products recalled in 2023 alone. And Missouri faced an unprecedented recall of 195 marijuana products in 2024. Beyond public health, this bill threatens Nevada's small cannabis businesses with local labs and cultivators that are at the heart of our industry. It jeopardizes squeezing them out, reducing competition, slowing down testing, and ultimately driving up prices for the consumers. This erodes the trust that we've worked so hard to build in Nevada's cannabis market. For the safety of Nevadans and the vitality of our local cannabis economy, I respectfully urge you to vote no on Senate Bill 157. Let's protect the integrity of our industry, learn from the mistakes of other states, and prioritize the health of our citizens. Thank you.
Thank you so much. Is there anyone there in Las Vegas that would like to testify in opposition? Yes, please fill the chairs. Please fill the chairs and proceed. Whoever would like to go first. Can you hear me down there?
Hello, sorry about that. Thank you for the opportunity to voice my concerns in regards to SB 157. I am Anthony Hattery, ANTHONY, for the record, and I am with DigiPath Labs. Firstly, I want to say thank you to all of my colleagues that have spoken in opposition to SB 157. I completely agree with the talking points mentioned here today. And just to build on what's already said, I'd like to add an additional point to consider around the safety concerns as they relate to medical patients of cannabis. In addition to the many differences between our state of Nevada and the other states that are referenced, it's important to note that Nevada has already harmonized the medical adult and the adult use programs under a single regulatory structure through the CCB. This marriage was deemed acceptable based on the strong testing safeguards that were currently in place. This means that larger lot sizes increase the risk of medical patients could receive an untested or poorly represented product. This is particularly problematic for medically vulnerable individuals. Immune compromised individuals, such as cancer patients, are more susceptible to contaminants like molds and pesticides. Even those who are not immune compromised, such as diabetics who use marijuana, may face heightened risks of certain contaminants. To take on these kind of public health risks for the people who are the most vulnerable for the sake of profit without any scientific backing would be a terrible mistake. And I thank you for your time.
Thank you. Next person.
Sure. Yes, thank you for the opportunity to voice concerns on SB 157. Like my colleague Tony here, I'm Todd Dankin. That's TODDDENKIN. I'm also with DigiPath Labs, and in consideration of time and respect for other speakers, I just want to say that I agree with everything that Jennifer, Alec, and Tony has said up to this point. I also wanted to add one specific example. Colorado had 1,619 products recalled in 2023. Missouri, an unprecedented recall of 135,000 marijuana products last year. And, California has even developed its own cannabis product recall portal so it can better manage these issues, really showing the scale of this problem. And Canada was mentioned earlier and said they have no problem. Well, Canada also has a portal for recalls. They've had hundreds of recalls over the last several years. And like I said, like California, they also have a portal where the affected products are posted, again, to stop risk to the public. And it hasn't been mentioned that Delaware and Montana also restrict the lot size to 5 pounds. And then in regards to the CCB, the Nevada Cannabis Compliance Board has already taken this issue up several times, most recently through 2023 and 2024 regulatory workshops. And the April 2024 workshop was specifically focused on lot size concerns. And after stakeholder feedback, no regulatory changes were made. And I know the big thing is cost. We heard that from Alec. It's about 8 cents a gram to test. It's not the thing that makes cannabis more expensive.
Okay.
Thank you.
Thank you. Next person.
Thank you for having me here as well. Nathan Siegel with MA Analytics. That's NATHANSIGAL. And once again, I'm with MA and Associates, MA Analytics Laboratory. I would also like to thank my colleagues and agree with my colleagues' statements today. And I also oppose this bill. I would just like to identify that this bill would adversely affect the labs. We are the safeguards of the industry, and any reduction in the sample flow to the labs or the reduction in the number of labs operating would just have an adverse effect on the safety and security of our products here in the state of Nevada. I yield. Thank you guys all for your time.
Thank you so much. Is there anyone else there in Las Vegas? Okay, not seeing any. Broadcasting, will you please open the lines?
Chair, the public line is open and working. There are no callers to testify in opposition at this time.
Thank you so much. Then I will open it up for neutral testimony. Not seeing anyone here in Carson City. I will go down to Las Vegas for neutral testimony.
Morning, Chairpersons. I'm Michael Miles, Deputy Director of the Cannabis Compliance Board. We're just...
Sir?
Sorry.
Okay.
Sorry, I actually hit the button again. Again, Deputy Director Michael Miles, MILES. We're here in a neutral position on this bill. I just want to affirm that we have had this discussion in front of the board multiple times from 2021 through 2024. The latest long discussion in front of the board was September 2024. And again, no changes were recommended to be made.
Thank you so much. Next.
Kara Cronkite, Cronkhite, Chief of Health and Safety for the Cannabis Compliance Board. I just wanted to point out that we, as well as many other states, have several different lot sizes for different types of products. For example, our flour, the whole flour that is not homogeneous, it is heterogeneous in nature, is limited to 5 pounds per lot. And then the trim, which is all the other plant matter, is 15 pounds per lot. And whole wet plant is actually 125 pounds per lot. And several other states have them segregated into different categories as well. Thank you so much.
Thank you. Is there anyone else there in Las Vegas wishing to testify neutral? Okay, not seeing anyone else. Broadcasting, will you open the lines?
Chair, the public line is open and working. There are no callers to testify neutral at this time.
Thank you so much. Well, then I will offer the bill presenters. Now, Mr. Adler, just to let you know, you're standing between everyone in this room and lunch. And we have floor. So I mean brief.
Well, Will Adler here, and my testimony's already up in smoke, but we'll try and grow to some conclusions together. I just want to state again that we're open to we're open to having real discussions, even at this date, about what is that right number for Nevada, and we would like to meet with the opposition to this time. But again, I just want to thank the Assembly Judiciary Committee for hearing this bill today, and that SB 157 has had a long and tumultuous history, but I think together we have some joint decisions to make, and that we're okay, and that that really this is a culmination of a lot of work, and that we do want to wrap it up as best we can. So we will hear with the opposition, but thank you for hearing us today and hearing SB 157. That is all.
Thank you so much. And with that, I will go ahead and close the hearing on SB 157. Last on our agenda today is public comment. Again, just a reminder that public comment is not to make any comments on any of the bills that were heard today, but anything else that is under the purview of this committee. So starting here in Carson City, if there's anyone that would like to make public comment. Not seeing anyone. Is there anyone in Las Vegas that would like to make public comment? Also not seeing anyone. Broadcasting, will you please open the lines?
Chair, the public line is open and working. There are no callers for public comment at this time.
Okay, thank you so much. Then I will go ahead and close public comment. With that, that concludes all of our agenda for today. Thank you, everyone, for their flexibility with all the comings and goings that happened. And as a reward, I will see you all back tomorrow morning at 8 a.m. All right, see you all back tomorrow at 8. This meeting is adjourned.